Diane, I didn't recall seeing them either, but they were actually in the email that Travis sent on July 29th.
Thanks, Lauren.
Yep. Dennis, I'm glad you mentioned them because I had to go back and scroll through a lot of emails.
Good afternoon.
Good evening, everyone. It's 5:30. Jeff isn't going to be in attendance this evening. And is there anyone that would volunteer to act as the chair in his absence? If not, I'd be glad to just run us through the meeting agenda.
Can we do that? Do we need to have a chair like call to order and stuff? I don't know what the rules are. Sorry.
I can do that. I can serve in that role if nobody wants to volunteer.
Works for me.
Okay. Well, I'll call the meeting to order at 5:31 and we'll show the current attendance of those that are on the Zoom meeting and those that are not. Travis will do that when he reviews the recording. If I could have a motion to approve the agenda this evening, which is approval of the minutes and then a presentation by Matt Brick.
So moved. Dave Faree.
Second from Lauren.
Okay, moved and seconded. All in favor, please say aye.
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 Those opposed? Okay, great. So then the next item will be the approval of the minutes from June 23rd, 2021. Do I hear a motion?
Move approval. Dave Faree.
Motion? Is there a second?
Second.
Okay, there's a second. All in favor, say aye.
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 Anybody opposed? Okay, good. With the approval of the minutes, now I'm going to turn this over to Matt Brick. Matt, we are sharing the screen with you for your power presentation. Could you please introduce yourself to the group for somebody that might be new and not recognize you? And then also if Aaron is present.
Yeah, excuse me. Good evening, everyone. I have asked Aaron to help out. As you can hear, I've got seasonal allergies and I apologize. I'll keep my voice to a minimum. Aaron Clanton and I are the two attorneys at our firm who do most of the work with the city of Windsor Heights and have for a number of years. I think many of you, excuse me, we have dealt with before. What we're doing tonight is Dennis has asked us just kind of go over and update some planning and zoning sort of basic rules in light of the fact that a number of planning and zoning commissions, including Indianola and Newton, have been sued this year. Meritlessly, we would add, but just want to go over the basics in case we get targeted by one of the developers who's targeted some other cities. And with that, I'm going to hit the start screen or start presentation and then not make your ears bleed anymore with my voice. So Aaron, I'll turn it over to you.
All right. Well, good evening. I hope you can all hear me. I'm Aaron Clanton, one of the other city attorneys. Thank you, Dennis, for having us here tonight. Our hope with this is really to just provide kind of a 10,000-foot overview of planning and zoning and your roles and responsibilities for the city. And we don't anticipate that we're going to answer all the questions, but what we do hope is that we at least can facilitate questions that you should ask, right? As you're reviewing site plans, amendments to the zoning code, what kind of things should you be asking yourself? And then I'm certainly going to end with the doom and gloom of open meetings and conflict of interest issues, because we have seen the conflict issues arise more frequently as well. And so just kind of reminders of situations that you don't want to get yourself into, so that you can avoid any kind of litigation. So Matt is running the PowerPoint, and so he's going to kind of alert me when questions come up, but sure, I mean, we have 9 people here, so feel free to just unmute yourself too, and I'm happy to answer questions as they come up. So with that, we will get started. Land use law, which is really what you guys are facilitating, is multiple parties. And so you've got your council, you've got your city planner, which I think you guys called it the zoning administrator throughout your code, so I apologize for that. The Board of Adjustment, and then you folks, the Planning and Zoning Commission. Move it, Matt. All right. So zoning has not always been something that's been allowed. And so I like to start with this just as a context for everybody about this delicate balance that you guys play between the city's roles and responsibilities and having a congruent city plan, right? And as well as people's constitutional right to use their property as they wish. So the case, it was a 1926 US Supreme Court case that ultimately held that zoning is a valid use of state and local government's police power. So if the regulations aren't arbitrary or unreasonable, zoning ordinances are constitutional under the police power of local governments, as long as they bear some relation, we're missing a word there, to public health, safety, morals, and general welfare. So, but as you know, zoning laws are still challenged. Not as frequently as we once saw, but they are still challenged under the takings clause of the 5th and 14th Amendments of taking people's property and their uses of that property without compensation. So the other thing I did want to say is that at the end of this, Matt has put this presentation into notes for you guys and a handout. So we'll circulate that as well. All right, so just some of the relevant code sections. This is where you guys find your authority to make the decisions that you make. Iowa Code 414.6 provides the powers and duties for the council to appoint the commission, known as the zoning commission, and for you to adopt a zoning ordinance. And then as well as the comprehensive plan, which you folks have already done, or your predecessors. So this section is from the Windsor Heights Code, and this is really what I would call your mission statement as a planning and zoning commission. So it's Windsor Heights Code 16503, the purpose of the zoning code, to serve the public health, safety, and general welfare of the city. Of course, that's the requirement, the required things that you need to serve in order to check that box for that 1926 court case, United States Supreme Court case. That it has to check those boxes, to classify property in a manner that reflects its suitability for specific uses, to provide sound, attractive development within the city, to encourage environmentalism of adjacent land uses, to protect environmentally sensitive areas, and to further the objectives of the comprehensive plan. So that's your mission statement as a commission, as well as with your zoning administrator. Windsor Heights Code 16504 just states that the zoning code needs to be consistent with the city's comprehensive plan, and to the extent that it's not, you folks can propose amendments, or the city council can propose amendments to make sure that those are consistent. All right, so primary duties of you as a commission. As you know, it's a 7-member board. The things that you consider are rezoning requests, preliminary and final plats, site plans, and then certain amendments to the zoning ordinance itself. You are appointed by council, and then you review applications in accordance with Chapter 170, which is your zoning ordinance. You hold public hearings, you consider matters with the comprehensive plan, urban renewal, zoning district amendments, text amendments, and similar things. Your terms are 5 years, if you weren't aware. Okay, so the zoning ordinance is the primary mechanism for implementing the policies of the comprehensive plan. It's very detailed. We're not getting into any of the details of your actual zoning ordinance tonight. As you know, whether or not a property or a site plan complies with the zoning ordinances, it's complex, and it takes a lot of time to go through and make sure that all of those boxes are checked. So we're not going to get into the weeds on that, but suffice it to say that that is kind of the Bible for this group. There are a number of goals that are achieved through zoning. You're trying to conserve and protect property values, encourage efficient and orderly development, so that you can use the public improvements that you have in place or that you plan to put in place in an efficient manner, to limit overcrowding of land and the congestion of population and transportation systems and other public facilities, to facilitate the adequate provision of water, sewage disposal, schools, parks, and other public requirements. And while you might laugh at this, it actually is in place to limit conflicts between neighbors. Now, we understand that conflicts between neighbors are going to arise, and a lot of times they arise because of things that are in the zoning ordinance, but really it's the attempt to treat every similarly situated property, right? We're talking about the property, not the property owners. And I'll say that again in a minute, but that those properties are treated the same. All right, so zoning helps to achieve these goals by controlling land uses, population density, building height and bulk, lot sizes, yard and open spaces, setbacks, et cetera. And I have this later on in the presentation. I don't know if it's provided to you folks when you're considering site plan review, but table 177.1 in your code sets out the criteria for site plan review. And it really is, I think, a very good table to set out the types of things that you consider. The primary duties of the commission are to establish and recommend amendments or modifications to the zoning code. So that's to the text of the code itself. And like I said earlier, that those recommendations can come either from the Planning and Zoning Commission or the City Council. You review applications and make decisions on new commercial and residential developments. You review site plans, provide comments on plats, comments on street and park improvements, and then develop, or in the case of a city like yours that already has a comprehensive plan, to do amendments to the comprehensive plan as needed. Matt, you're doing a great job of forwarding through these. Okay, so site plans. This is kind of just a snapshot of the process, which I'm sure you're fully aware of, but the application is submitted by the owner of the property or their agent, and it's filed with the zoning administrator. If someone comes to you and wants to know how they find those forms, they can find them through the office of the zoning administrator. And the application has to check all those boxes in chapter 170 that we talked about. The zoning administrator then reviews the site plan, make sure that it does meet everything that's required in the contents of your zoning ordinance. And then the zoning administrator provides a written recommendation to the Planning and Zoning Commission as well as the City Council. In certain cases where there's significant impacts or effects on traffic circulation or other significant effects on adjacent neighborhoods, there can be additional reviews that are required. And again, we're not going to go into the weeds on that, but just so you know. Okay, so your code says that in reviewing the applications, the Planning and Zoning Commission shall make the following findings. One, that the proposed development, together with necessary modifications, is compatible with the criteria established in chapter 170. Two, that any required modifications to the site plan are reasonable. Three, the site plan conforms to the zoning code and to the vision of the comprehensive plan. So you guys are going to make those findings, and then you make the recommendation to the City Council to approve or deny. Sorry, I got a tickle there. Okay, so these are some of the things that the commission considers when they've got a request in front of them. And again, a lot of this comes from that table 177-1 in your ordinances. So this is not exhaustive by any means, and that table is very helpful to look through. But you're going to look at the conformity with the comprehensive plan, changes in population density, the changes to traffic or public facilities, units per lot, lot size, open spaces, green spaces, play areas, landscaping and buffering, highest and best use of commercial property, whether the zoning would be considered a spot zone that is going to give one landowner a privilege over others in surrounding areas, whether the proposed use negatively impacts property values, whether there is properly zoned areas in the community that could accommodate the proposed use. If the change is approved, whether you're going to see similar rezoning requests in the vicinity, and whether or not there was a mistake in the original zoning classification that would necessitate perhaps a change in the zoning ordinance text itself. Okay, so this is usually where we find ourselves getting into problems of things that the commission should not consider when they've got a request in front of them. Happens, we see this on a shockingly frequent basis. So these are things that we don't like to hear being said in open meetings. The type of people, so these are things you shouldn't consider. The type of people that might be living in proposed housing should not be a consideration. Whether you like or dislike a certain developer. The economic, racial, religious views of an applicant, who the owner or developer is. And I said this in an earlier slide, but you folks are really talking about the use of property, not who those property owners are, because the decision is going to live with the property, not with the property owners at the time. Whether earlier promises have been made by individual commission members to the developer or the owner. One of the last slides that we're going to have is going to be talking about, excuse me, open meetings, as well as some conflict issues. And we see this a lot, and it's usually not with any malintent, but developers will reach out to individual commission members, or sometimes they'll reach out to individual city council members and want to talk about a project in advance. And whether or not that turns into a rolling meeting, which is where, you know, the developer talks to one commission member and then talks to another, and then they talk about what they talked about, and there's some perception that a decision is being made outside of an open meeting. Whether or not that actually happens, there is the perception that it may. And so it creates an argument that doesn't need to be created. So those discussions, those meetings with the developers should happen in an open meeting where you guys are all in attendance to ask questions as needed. Another thing that should not be considered is whether an earlier zoning application for that property was denied. So that shouldn't be the sole basis that you guys deny an application, is that you've seen an application for that same property at an earlier date and it was denied. It still should be considered. Presumably it's a new application with hopefully checking most of the box or more of the boxes than it did previously. And also you should not consider an attempt to regulate or prevent competition. So if you have a site plan in front of you that's for a new restaurant to go in, just because you've got a mom and pop shop down the street that's also a restaurant, and you might fear that that competition might take business away from them, that cannot be the sole grounds for denying that application. So there's all sorts of other things that might come into play with that, but just the competition itself cannot be the grounds for denying the application.
And excuse me, I want to go back to, I mentioned earlier that we are dealing with one active lawsuit and one that's on appeal right now for two other cities. And the one is specifically that P&Z and then the council denied the platting request. And it was specifically said during both hearings that we don't like the people who might live in this housing development, and that we don't like this developer and what they've done in the past. So we have a current lawsuit involving the second and third bullet points that Aaron mentioned. And then also we have another threat of litigation by the same developer against another city right now, involving promises made or allegedly made by the commission members. So these are things, while they are fairly standard and straightforward in the law, they still happen quite frequently with other planning and zoning commissions, and we just want to protect you to the extent we can.
All right, so this is kind of my summary slide. Like, this is the slide to take with you. that kind of sums up the last few, but zoning ordinances are extensions of the city's police power, and they are to be strictly construed in favor of the free use of property. So back to that 1926 court case, zoning arguably is a violation of an individual's constitutional rights to freely use their property. And we've been granted, the cities and municipal local governments have been granted an exemption in the way of this court case that allows for this type of use. But where there is ambiguity, you need to construe that in favor of the property owner. Now, that doesn't mean you can't go back and revisit the language in the zoning ordinances and propose amendments to be made at a later date. That won't impact this particular application, but could future ones. Doesn't mean you can't do that, but if there is ambiguity that it could go either way, you need to be looking at it from the standpoint of the property owner and their constitutional right to use their property. This slide is just a quick overview again of the process to amend the zoning code. Amendments can be initiated by you as a commission or by the city council. And then rezoning applications are initiated by the property owner, planning and zoning, or the city council. And then the process to amend, the application is filed with the zoning administrator. And then there's two types of notices that need to be provided. And you guys, I don't know if you guys handle that or the city clerk does all of this for you, in which case it's a wonderful thing. So maybe you don't even know that this all has to happen, but you have the publication 4 days, at least 4 days prior to the hearing, that there's going to be a hearing on the matter. So that publication goes out, and then the applicant provides a list of all of the adjoining property owners within 500 feet of the site to the clerk, and then the clerk sends all that out. So once all those notice provisions are done, you as a commission have your hearing on the proposed text or the rezoning, and you then provide that recommendation to the city council. The city council then has the similar procedures to go through in terms of notice proceedings, and they have a hearing as well. If you as a commission have recommended approval, then it's just a simple majority of the city council to approve that. If you are proposing as a commission to disapprove the action, then it's a supermajority, a majority plus one of the city council to approve it. There also is the ability for eligible property owners to file a protest with the council, in which case it would be another supermajority required to approve the request. Okay, so as I warned you, my last few slides here are on open meetings, open records, and then conflict of interest issues. Just things to remind yourself of as you're trying to balance this being an individual in the community and a public servant as a member of the Planning and Zoning Commission. So Planning and Zoning Commission meetings, as you know, are subject to open meetings, and you're also subject to open records. Parties that are involved in the application process and redevelopment process are entitled to the same fairness, impartiality, and independence of judgment as one expects in the court. To ensure compliance, outside communication regarding a project to be reviewed by the commission is discouraged. And again, we recognize and realize that this does happen. We recognize that it's a small community and you know a lot of people, you likely know a lot of the developers. But just be wary of discussing the intricacies of a specific project when you're not in an open meeting where everyone else can participate in that meeting. Communication outside of the public meeting creates the impression, real or perceived, that you're violating open meetings laws. And again, there's the Warren County case that's out there that we always warn our clients about these rolling meetings. And I touched on that earlier, but it's really where you're not all meeting. Very rarely do we have a case, right, where we've got a majority of the city council or majority of the Planning and Zoning Commission or a majority of the BOA that literally sit down and have a meeting with the developer, not in an open session. That doesn't happen. But it's where you all have side meetings with the developer, and then there's conversations either between the developer and one commission member that says, oh, I met with so-and-so the other day, and this is what they said about my plan. And then I met with so-and-so on the other day, and they said this about my plan. That becomes a rolling meeting. That is the problem that we're always very cautious of. So This is really just a cautionary tale to protect each of you. Any members of the commission that have been contacted by an applicant or interested party should note that at the beginning of the discussion in the open session that they were contacted, and if there was any discussion, what that discussion was.
Erin, can I ask a quick question on that?
Sure.
When it says who's been contacted by an applicant or interested party, when there's a personal connection to somebody, you haven't talked about the issue at hand. Is that something that we disclose as well, or what's the best practice for that?
No, this is just with regards to the content of the application or the project that they're considering. Now, if you've got a personal connection with somebody, it doesn't hurt for you to say, hey, listen, I have this relationship with this person, but we haven't discussed the project.
Okay, fair enough. Thank you.
Yeah, you don't need to disclose all the conversations you've had.
Well, sure. Yeah.
Okay, so conflict of interest issues. The next slide is going to have, the slide after this one is going to have a whole host of different things that could be considered conflicts, and I won't read through all of these, but it is this delicate balance for you guys, as I said earlier, between your public duty and your private interest. And so the two most common conflict issues that we see is when you stand personally to financially gain from the decision. So you or a spouse or an immediate family member that might financially gain from the decision, or when you are a relative of the interested person. So, and I should say party instead of part, I apologize. If you do have a conflict, you just disclose that at the beginning of the discussion. I know this says no at the vote, and then abstain from voting. So prior to the discussion, you should say that you have a conflict, what that conflict is, and then abstain from not just the vote, but also the discussion prior to the vote. If you don't have a conflict, this might seem unusual, but we have seen it where it just seems uncomfortable because you do somehow know the person, or maybe you did have a discussion with this person, maybe before you were appointed as a commission member, that you would support their project, right? So it might not be anything nefarious, but it might be uncomfortable at the time to take a position on it. But it is your duty, if you don't have a conflict, to participate in the discussion, to ensure the compliance with the zoning code that you've created or amended, and then vote on the matter. And so this has a whole host of different types of conflicts that might arise. Obviously, if you're an owner of the property or an owner of the business that's filing the application, you should abstain from any discussion and vote on that matter. If you have a business relationship with the applicant, if you have an immediate family member who might benefit from the decision, or more likely, and more likely to raise us think about it, is if they're going to be harmed by the decision, and it's an immediate family member, right? So it's a spouse, it's a child, then you should abstain from that vote. You're employed by a company that might have some financial gains from the approval of the proposal. So I've got a whole list of things listed there, but if you are one of these people, the attorney, the developer, the subcontractor, and you've got a contract that you might benefit from the development that's being proposed, you should abstain from any discussion and vote from that as well. And then obviously if you got a realtor or an attorney or somebody who's working for the applicant, you should abstain from discussion and vote on that matter. So with that, that's what we have for you today. Happy to answer questions or try to answer questions, or come back to you with additional information if you request.
And Aaron, I'm not going to scratch anyone's ears. Can you explain, if there is an open meetings violation, who's the agency and what's the penalty or remedy?
Matt, I know you're talking, but I did not hear what you said.
Sorry, let me try that. Can you explain an open meetings violation? Who would be in charge of looking into that, and what's a possible remedy?
Oh, so likely you're going to see a complaint to the ombudsman with regards to a violation or IPIB. the Iowa Public Information Board. There are statutory violation amounts. I think it's $500 an occurrence. Is that right, Matt?
Correct.
But okay, so it's not something to turn a blind eye to. I mean, it's a significant violation, and certainly not one that you want to. In addition to that, you typically find yourself in the public eye, which is more of a problem than the financial fine that you see.
Is the fine paid by the city or by the members themselves?
Matt, can you answer that?
Yeah. If IPIB finds that it was reasonable for the board members to take the action, or if like legal counsel or the city clerk told them, hey, this is okay, there are indications that the city can pay the fine. If it's found that the board acted against legal advice or the advices of the city clerk, there are cases where they say the fine is to the individual and the city can't pay it. So most of the time, you guys, if you're concerned about something and you ask the clerk, or if it's a very concerning meeting and you ask legal to show up, you're going to have protection. It's the rare circumstance where you get really bad advice and they think you should have known better, or you ignore the advice. The other thing I would mention, and I might ask Aaron to explain it, is we do have 2 suits going right now. Both suits we have ICAP, the city's insurer for Windsor Heights, is the city's insurer for the other cities. And in both cases, the commission members are all protected. But just to scare you guys a little bit, if Aaron could kind of explain to you the issues we've had with ICAP in the last year or two about always representing elected or appointed officials.
Yeah. So we have seen the position be taken by ICAP in more recent years that if you as a commission member or a city council member, as we see in more cases than not, is acting outside of the scope of your duties, right? If you're making decisions that you shouldn't be making, you're making considerations that you shouldn't be making, they may deny coverage. And that should be really scary, because the city might have coverage and the commission itself might have coverage, but you personally would not have coverage. And we are seeing more often than not that plaintiffs' counsel are using this shotgun approach to litigation. And so they're not just suing the city and the commission, they're suing the city and the commission and every commission member and the staff member who made the recommendation and anyone up the chain. And so it creates a more complex litigation and more likely to settle, which we are also see quite a fair amount with ICAP. But so you will see sometimes at meetings, in particular, like when, if, for example, in a city council meeting, if you're going into closed session for some particular purpose, you'll hear the city administrator or the city clerk ask the city attorney, do we have grounds to go into closed session? And the city attorney can say yes. And that gives you guys all cover to say, we went in at the recommendation of legal counsel. And so when you've got a recommendation in front of you to approve or deny something, and be able to say, we've had legal review this and legal supports this recommendation, really what that does is give cover for all of you. How is that for a long-winded response, Matt?
Typical lawyer speak.
Any other questions we can take for you?
This is Dave Free. I have a question about our flexibility. If, for example, a developer comes in with a plan and says, I can comply with everything in the zoning ordinance except I would like to have this particular requirement waived, or whatever term they use for that. What kind of discretion or what kind of power do we have to do that?
Well, I mean, that's really a special exemption that really should be heard by the Board of Adjustment and not Planning and Zoning, if they are wanting an exception from the code that you have.
Thank you.
You're welcome.
I have a question to follow up to that question. It seems like a lot of the requests that we see have something that brings it outside of our code, and we have the recommendation from either the engineers or whoever that approving that it's okay to basically approve it. We have the discussion and decide whether or not to approve that change, even though it's not in line with the code. Thinking back to our conversation last time about the Hy-Vee construction, and then honestly, probably 2 years ago now with sign lighting, that technically that sign was out of compliance with the code. So we should not be granting that approval or making the recommendation, I should say, to council to approve it. We should be sending it to the Board of Adjustments, or am I misunderstanding the instructions?
No, you're hearing that correctly. And so typically how that would be handled, and Dennis, I don't know how it's been handled, so I don't want to, maybe I should let you speak first.
Well, municipalities do it different in a different order. My preference has been to get the variances out of the way first and then go to the planning and zoning. So if there's a development that comes forward that, say, needs a variance for, I don't know, floor space or whatever we might have in our code, our preference would be that we go to the Board of Adjustment, they discuss it. If they say no, then that might be the end of it, or they may have to go back to the drawing board at some point. Better to do it there than to waste everybody's time and get to the end and have the Board of Adjustment say no. So our preference is Board of Adjustment, Planning and Zoning, and then all of that package goes in one big gift box to the council.
So Dennis, does that mean like the Hy-Vee, the parking spots per square footage or whatever issue that we talked about last time? Does that mean that the Board of Adjustments had already approved the variance?
No. So there are going to be instances where a variance isn't thought of, or and I want to say in the Hy-Vee situation, it wasn't so much a variance as it was a preference. And the staff was making a recommendation that their site plan review met the development standards of the city, but the planning and zoning can also add on its own conditions of approval. And a good example of that would have been the brick facing that the council finally added on to that project. So the Planning and Zoning Commission could say to the applicant, listen, we want to maintain a certain consistency in the brick facing along the University Avenue corridor. And even though it's not a minimum requirement, would that be something you would do for us to maintain that consistency? And that would become a condition of approval if the applicant agreed to it.
I think I'm following. I guess I'm still a little confused that because I thought the parking space issue for Hy-Vee was a code thing. Was it not?
It was my understanding that they met the minimum parking space requirement.
I think they only did if they included the drive-up lanes, if I'm remembering correctly. That if they counted the drive-up lanes for people potentially waiting to pick up their groceries, then it met the requirement. And so I thought that was part of the discussion last time. I don't know if the rest of the Planning and Zoning Board tuned into that next City Council meeting, but Councilwoman Skiri's mentioned that when Come and Go's facade was approved, they were asked to put in extra brickwork at the gas pump island or whatever, and requested that Hy-Vee do the same for consistency. And that was, I think, some of the institutional knowledge that maybe we're kind of short on right now, since we don't have, I wasn't on the Planning and Zoning Board when that conversation happened, but Susan remembered it from way back when. So that was one thing that I wanted to figure out, how we can rapidly gain a bunch of institutional knowledge, I guess.
Well, also to kind of bring back that institutional knowledge, the city council, which is the only authority that can do this, agreed to throw $20,000 at their project back when that brick facade was requested. So unlike that, this time Hy-Vee was gracious enough to say, we'll be glad to do that at our cost, and you don't have to throw any money in. So there was a little bit of a difference there. Whenever the city's willing to throw money at a project, the developer is more than happy to abide by additional requirements.
I'm sure. So from what I had a couple of questions that I jotted down beforehand. Sorry, I just want to make sure I understand. So when something is presented to planning and zoning, we have the option to approve or deny based on everything that Aaron has shared on those slides. But then we can also request modifications. So that kind of goes back to the questions that I thought somebody else had asked. Mr. Furry had asked about, we can request that modification. We can request, could you add more brickwork? Could you do these types of things? That's within the scope of our role in the commission.
I think, Aaron, you can back me up on this, but you can ask for whatever you want to ask for. But if they're already meeting the minimum development guidelines, then you do not have a basis for denial unless you can point to that section number 8 that says they don't meet that criteria. But in these situations, more often than not, there is a give and take between the developer and the city. We try to, as a staff, flush those out ahead of time. If the developer says to us, hey, we're going to need a variance on the width of our driveway, for example, we can say, well, that's great. And we will support that because of the data that supports or that doesn't create that as some kind of conflict, traffic conflict. But at the same time, hey, over here, we'd really like it if you did the brick facade. And we can work that all ahead of time. We can do our best, but the council ultimately will be that deciding group. And it's really good that this group comes up with those ideas and concepts. I continually recommend that you do that because the council would like to hear your conversation. So if the planning and zoning said, okay, we've approved this, we recommend its approval, but we would also like the council to consider these 3 additional things to make it a better development, maybe requiring the city to give money towards the project. I think that's a great process that comes out in the end with the best development.
Thank you. That clarifies a lot for me on what we can and can't do. So thank you, Dennis.
Mm-hmm.
As this is Dave Free again. As I understand the discussion today, there's a difference between requiring additional items in the site plan and excusing items that do not comply with the zoning ordinance.
That's correct.
That's correct. Yeah, so if they don't meet the minimum requirements, they're asking for something special, a special exemption. And that needs to be heard by the Board of Adjustment. But if you want to say, ask for additional things on top of, if they've met all the minimum requirements and you as a commission think that it would be better to add certain things, that can sure be part of the recommendation.
But to go one step further, Aaron, please clarify. If the Planning and Zoning Commission does not have a basis in our code to deny, then they are obligated to approve a site plan.
Correct.
Yeah, we can't act arbitrarily.
Right.
Right. And I mean, if you don't like what's in your zoning ordinances, that's when you can take those steps. And it might not happen with the specific developer in front of you, but take those steps to consider some language changes to the ordinance itself.
A lot of times we learn by experience.
Amen.
Are there any other questions of Matt or Aaron this evening? Well, Aaron, Matt, thank you so much for taking time. I think we might call upon you in the future to address another topic within the zoning code, if that's okay.
You bet. We're happy to assist however we can. And like I said, we will, Matt, you have the emails for all of the commission members?
Yep, and it's going out right now.
Okay, awesome. So we'll circulate the slides from this presentation so you can have them and mark them up. And if you've got specific questions, go ahead and forward them through Dennis and we can respond as needed.
Thank you. For everybody's understanding of how this came about, I wanted to give you a 2-minute kind of a recap. Jeff and I met about a month ago and we talked about the role of the Planning and Zoning Commission and what their responsibilities are. And we boiled it down to 4 things that we wanted to make sure that we were always pursuing during the year. And those 4 things were training, which is basically this evening's meeting, review of the zoning ordinance. So even if we might not have a project in front of us, because Windsor Heights doesn't have a lot of development opportunities, they come few and far between. But when they do come, we want to be utterly prepared as best we can for those site plan applications and those rezoning applications. So there was training, reviewing the zoning ordinance, site plan approvals, and rezoning requests. Those were the top 4 things, and we want to be ready for all of them when they come to us. We do know that we have a Casey's project that's still sitting out there in limbo. When that finally gets to the Planning and Zoning Commission, we want you to be totally equipped to be able to handle that application, ask good questions, understand what our zoning code says, and put together a good project for that Casey's project. So that's where we're coming from. Tonight's the first one. We're going to continue as a staff to put together training topics. And even if we don't have something for a meeting agenda, we're going to give you or try to give you a training of some type. Now, if you have some of you have been on the commission for quite a while, and you may have more experience in these kind of things, and you can kind of pick out what things are going to be maybe confusing or contentious, send those to me, and we'll be glad to put together a training session either with Matt or Aaron, or we also have resources at the league that we could utilize as well. So that's kind of a background of what we're starting to do tonight. If there are other things that you'd like to discuss at an upcoming Planning and Zoning Commission meeting, please let Jeff or I know, okay?
Thank you.
Thank you all for coming tonight. I appreciate it. If I could get a motion to adjourn.
I motion that we adjourn. This is Georgie.
Hi, Georgie. Thank you.
Hi.
A second? Okay, all in favor of adjourning, please say aye.
Hi.
Nays? Okay, thank you very much, everybody. Have a good rest of your evening.
Thank
Thank
you for
you.
doing this.
Good
Thank
night.
you.